And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness.
No,
I have seen an annexure here.
Can I check, yes?
I've seen an annexure there. You are given an annexure that has. Is it yours?
Yes.
Or it is on it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting these orders?
Council,
No.
it's a draft.
Which is saying, is the office of the DPP or Ipoa that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality? That in this court, already you have decided, not the court itself? Who decides? Who decides? I hope it ceases.
I hope we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client.
We have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
There's not done so much on that here. Yes. I think what Mr. Witt is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not a good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, you know what I said? If an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching till he's late on the forum.
It's our
we just try to let you know that it will be a difficult one. After Mr. Shadrach, Mr. Keto will clear his legal cases, then I'll wrap up the application. I think Mr. Umbeta and Mr. Njui will be making a submission on that.
Your Honor, with your permission, I will ask very few questions to my colleague Mr. Jibril. Unlike my seniors are on the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law. Let's relax.
Okay.
Yes.
The problem is his body. Cliff, make sure he eats well.
Thank you. Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please, repeat the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Edward Lagat.
Yes, Your Honor.
Thank you. you also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we have agreed that what I'm going to answer is what is...
of the Constitution allows for limitation of rights. Under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Join Ngugi J, as he then was, in Sudi Oscar Kipchumba.
The DPP is making submissions. They waive the right of making submissions after we have made our submission, so that once they have done this, they will surrender this for cross-examination. And they have no right. Procedurally, it is the deponent to be put on the dock and the deponent is cross-examined, the respondent's lawyers submit, and the state submit. But now it's the reverse. And that's what I'm asking. Is my old JV abdicating the role?
My understanding was just laying a basis so that once the deponent comes to the dock, then they can proceed from there. Yeah. So let JB just finish with your laying your basis. I believe it's more or less like an opening statement.
He has done an opening statement.
Yes, let him finish.
Then be doing an opening statement to lay the basis.
Yes.
And counter what I've been saying, because he's doing actually an opening statement. We'll also be seeking that we also put an opening statement and before the court.
So please.
Sorry, Your Honor. I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. So, Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so, even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged, and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith, and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. You know, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail, while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. Yon I dare say kizungu kubwa. having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
All right, thank you.
Thank you.
Your Honor Makori, Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I will only I will only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation, and these are the preliminary investigations by Ipoa, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious applications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/7/6/2025.
Read it again. 10/7/6.
That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested, and this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest